Attorney.
There we go. Okay. Mr. Butler, you're the appellant.
Yes, Your Honor.
Are you ready? Both sides ready? Let's go.
Yes,
20
Your
minutes.
Honor. Good afternoon. My name is Jesse Butler. I'm here on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal, if I may.
Yes.
Thank you. We've got two issues that we have appealed, primarily with regard to the court's abuse of discretion following a jury trial. I'd like to start with the second argument in our brief that had to do with the improper closing presented by plaintiff's counsel. Florida law is very clear that what plaintiff's counsel did in this case is improper. Plaintiff's counsel, having moved in limine to exclude evidence and arguing that evidence, the date that he was involved in this case, and specifically that the doctors who were treating under a letter of protection knew that the plaintiff was represented the entire time of their treatment. Plaintiff's counsel argued before trial that the jury shouldn't hear that it was irrelevant, that the fact that there was an LOP, well, first they argued that shouldn't be in, but they argued that any reference to the plaintiff's firm, any reference to dates should be excluded. Having won that argument, counsel then, during rebuttal, when there was no possible time for defense counsel to respond, took advantage of that ruling and actually misrepresented the facts to the jury. Counsel stood in front of the jury and said, our office wasn't even involved in this case until January 2018. That was false. It was a blatant misrepresentation. Counsel knew he had just excluded all the evidence that
your opponent has a slightly different take on how you got to where you were in closing argument. If I understood the briefing correctly, their view of it was that your trial counsel managed to get some of that information in and that they rebutted it. Help me, if I'm wrong about that, you'll educate me.
Yes, Your Honor. Plaintiff's counsel is incorrect on how this came in front of the jury. So there's two issues that they primarily argue. And their brief, they don't really even argue that what plaintiff said was proper. What they say is, well, there was a hearing and the court didn't explicitly prohibit this document, this authorization from going to the jury, and didn't expressly prohibit some testimony from Dr. Brotherton. But that's not really what the court did. There was a hearing on the objections to both Dr. Mazur and Dr. Brotherton, who are in the same practice. It was a hearing on the deposition objections. The supplemental record highlights what those objections are. The plaintiff's trial counsel argued, and it's at page 1341 of the record, when they started this argument over the objections, he says, we're talking about Dr. Brotherton and Dr. Mazur's deposition. As an example, he says, let's look at this section of Dr. Mazur. And then there's prolonged argument, and the court says, okay, I'm going to order the parties take out references to the plaintiff's counsel and to the date and to the fact that the doctors knew from the start of their treatment of this individual, Mr. Moore, that he was represented by counsel. Ordered that. Now, the court then goes on to another issue. What's notable is the answer brief, on the one hand, says, well, the judge didn't expressly exclude this. But then going on later in the answer brief, the counsel says, counsel certainly violated the spirit of the ruling, saying that the defendant, by introducing the LOP, violated the spirit of the ruling. Clearly, both sides understood that the judge's ruling was you have to take out any reference. Even though he expressly was dealing with one section, that was an example. And attached to the motion for rehearing that the defendant filed were the emails, which are at page 1391. Following this email, plaintiff's counsel is saying, here are the sections that need to be redacted based on the judge's ruling. So plaintiff's counsel is taking the position that all of this needs to come out. What they are arguing as well, the defendant got the LOP in, which first of all, the judge never said had to come out. That went in. The LOP, which is at page 817 of the record, which is called an authorization and promise of payment. Plaintiff's counsel below tried arguing it wasn't an LOP. The trial court said, I don't care what you call it, it's an LOP. That document is notable, and it's different than what defense tried to get in. because although it's dated 11/21/17, it doesn't specifically list the plaintiff's law firm on that document. This is a document that the doctor's office generates. That is different than the authorization for medical records, which was at page 1359 of the record, which was a document generated by the law firm. And it specifically says that Marlon Moore authorizes the medical office to provide to the law firm of Tandy, Griffith, and Bresler, PA, the following records. The law firm is mentioned 3 times. It talks about this is for a personal injury claim, and it's dated 11/2017. And there's a fax receipt showing it went out in December of 2017. So that is very different than just the blank LOP that just says I'm going to be treating, and if there's a claim, it shows definitively that there was a claim, that plaintiff was represented. And more than that, what plaintiff told the jury was false. I mean, it was just blatantly untrue. When he told the jury in closing, our firm wasn't involved, he said, November 21st, we became involved with this January 3rd of 2018. He's trying to downplay the significance of the letter of protection. He's saying, look, I know they showed you a letter of protection from November, but we were not, he says, we were not involved until January 2018. That is false. And he's trying to downplay the potential bias of these the doctors by misrepresenting facts that he knows is untrue based on taking advantage of a motion that he won. So I don't see, this argument that, well, this really doesn't matter. There's no prejudice because they got the LOP in. As I said, the LOP doesn't have the same information. It doesn't adequately respond to, even if it did, I mean, defense counsel can't do anything at that point on rebuttal, can't get back up and say, well, let's take a closer look at that. That evidence was supposed to be excluded. Plaintiff's counsel said the jury shouldn't hear the date we were involved, and then gets up and says, hey, we weren't actually involved until 2 months later. So, and that's, to me, a blatant example of the type of closing argument that this court and other courts have found is an abuse of discretion for the trial court not to declare a mistrial. I mean, in State Farm versus Thorne, this court about a decade ago said, it's improper. The law on this point is clear. Case law indicates it's improper for a lawyer who has successfully excluded evidence to seek an advantage before the jury because the evidence was not presented. That's exactly what happened here. And we cite a number of cases in our brief. I mean, there's no way around it. They argued this should come out. They got their way. Everyone acted as though they got their way. And I wanted to point out in the Allstate versus Lewis case, which we cite, 2009 from the first DCA, that had to do with a motion in limine. And the court said, although the trial court did not explicitly rule on the motion, it's apparent from the discussion before and during trial that the trial court and the parties understood the motion had been granted. That's very similar to what happened here. Plaintiff's counsel moved to exclude all this. The judge said, yeah, you've got to take it out. And though the trial judge didn't go line by line through every deposition, plaintiff's counsel following the hearing says, hey, we won that issue, all this has to come out. And everyone acted as though that's what happened. And then they took advantage of that. So, I mean, on that issue alone, I don't think that kind of conduct can be condoned. And we know it was important to the jury because during their deliberations, they sent out a juror question asking for more information about this authorization and promise of payment. This was on the jury's mind during their deliberations. And what they were left with, the last thing they were left with was false information that plaintiff's counsel wasn't even involved during the first couple months of Mr. Moore's treatment with these doctors. That was what they wanted to leave the jury with. And that was blatantly improper. The second issue that we've raised in our brief is the trial court's failure to strike the plaintiff's expert, Dr. Kowalski. And the issue essentially, I think, comes down to 2 primary issues. First off, the court failed to conduct any kind of Binger analysis as to whether the untimely disclosure of Dr. Kowalski's opinions should have been excluded under Binger. And I would point out in Montero, the third district said it's incumbent upon the trial court to analyze the Binger
But
factors.
before you get too far into that argument, why was Kowalski called late? Can you explain to me what happened?
Yes, Your Honor. I acknowledge, I mean, I was not trial counsel, but reviewing the record, there were issues with both sides trying to get discovery from the other side.
Was he called in rebuttal?
He was listed as a rebuttal expert. And part of the problem here.
And was he called in rebuttal?
Yes, Your Honor.
So you acknowledge some fault was on trial counsel?
No, Your Honor. What I want to point out is that Dr. Kowalski was listed as a rebuttal expert. Weeks, if not months, before trial, defense counsel moved to strike Dr. Kowalski as an expert because they had been trying to get his opinions through discovery. Plaintiff's counsel never gave those opinions. There was a hearing about 2 weeks before trial where a motion to strike Dr. Kowalski was heard based on defense counsel arguing, Judge, I don't have this guy's opinions. They won't give me a deposition. I don't know what he's going to say. The trial judge ordered that his deposition take place about 2 weeks before trial and ordered the plaintiff to provide Dr. Kowalski's opinions to defense counsel ahead of that deposition. Neither of those things happened.
You took the counsel took the deposition of Kowalski, correct?
Eventually, but Dr. Kowalski failed to appear at his first deposition 2 weeks before trial, and plaintiff's counsel didn't provide the opinions that the court said you need to provide. Defense then files an emergency motion renewing its prior motion saying, hey, we still don't have this guy's opinions a week before trial. And the judge orders that the Friday afternoon before Monday trial, defendant will take Dr. Kowalski's opinions and that the opinions should be a report or something should be disclosed before that. Defense counsel doesn't get those opinions. So Friday afternoon before trial walks in blindly to find out for the first time what Dr. Kowalski's opinions are. Then during the trial, obviously at that point, having only taken the deposition the Friday before trial, there's no earlier time to file a Daubert motion than during trial. And plaintiff's or Appellee's counsel, mentions in the brief, well, it wasn't until the fourth day of trial that we brought up the Daubert motion. But how is defendant supposed to bring up the Daubert motion any sooner when the deposition revealing the lack of the basis, a scientific basis for these opinions?
Well, I have a question. The argument was that Kowalski wasn't qualified. Is that the sole argument for the Daubert hearing? He was qualified, but everyone seems to agree he was highly qualified as an expert witness. I
think the issue, Your Honor, is he is highly qualified as a medical doctor. He does have a background in engineering, but the trial court, the issue is the trial court never did an analysis of whether Dr. Kowalski was qualified to give biomechanical engineering opinions.
Okay, was that specific argument made in trial?
Yes. And again, what happened was defense filed a written motion. Defense was then forced into arguing a very abbreviated hearing right before Dr. Kowalski was called to the stand, because again, the deposition wasn't taken until Friday afternoon before the start of Monday trial. And that's part of the Binger analysis that didn't take place was this going to disrupt the trial? Because defense is saying, this guy, we don't have his opinions. They shouldn't be allowed to call him.
Well, there was no motion to continue, was there?
I don't believe there was, Your Honor. And the case law says at that point, defense shouldn't be forced to ask for a continuance was there a showing of prejudice? Well, that's the thing, Your Honor. Once the argument was raised that this was an untimely disclosure, their position was, well, we disclosed him on a witness list, but they never disclosed his opinions. There was an obligation to actually do that analysis. As the court in Montero, in 2021, third district case said, it's incumbent upon the trial court to analyze the Binger factors before exercising its discretion to admit or exclude late disclosed exhibits.
Mr. Butler, did you want 5 minutes for rebuttal?
3 minutes, Your Honor.
All right, keep going. You're only at 5.5.
All right, thank you, Your Honor. So the court in that the court said the trial court's failure to do so will result in reversal. Here, the court never analyzed, never made findings, never even analyzed prejudice, never analyzed whether this was going to disrupt the trial. And what we see is it did, because by being forced into taking an 11th hour deposition, the Daubert challenge couldn't be brought until mid-trial. And at that point, we have another issue where the trial court fails to conduct a Daubert inquiry, and it fails to do any kind of Daubert analysis, even though the written motion is a Daubert motion challenging not just his credentials, but his methodology. And it's very abbreviated. Appellate's counsel here says, well, it was only 6 lines or something of the record. But how much longer can it be when you're literally having this argument before the witness is called to the witness stand? Defense counsel says we file the motion, challenges him under Daubert, and the court, under Ban, which is a first district case, 2015, the proponent of expert testimony must, when properly challenged, establish the basis for its admissibility by a preponderance of evidence. That didn't happen. They never, the proponent, the plaintiff, never tried to establish why his testimony met the Daubert standards. In Kristen, first district case from 2021.
You're at your 4-minute mark. You can keep going if you want to.
Thank you, Your Honor. But in that case, in Kristen, the court said, this does not mean the trial court, even during a bench trial, has the discretion to decide not to perform the gatekeeper function at all. And it's an abuse of discretion for the court to abdicate its gatekeeping function under Daubert. That's what happened. I, in some ways, have sympathy because we're in the middle of trial, right before the witness is coming up. I don't, in some ways, fault a trial judge for being hesitant to having to do a Daubert inquiry, but that's what was required. The issue was raised that this expert, who I should add, he says during his deposition, big red flag, I'm different than other biomechanical engineers. He says he starts with a medical diagnosis. He starts with a differential diagnosis, which by that point the court had struck. And if you read his trial testimony, there is not, his testimony boiled down to if the vehicle Mr. Moore was in was damaged, then I've read studies that show he must, that the amount of force necessary to cause crush damage, even in a low speed impact, is sufficient to cause some injuries to somebody. And I've read that somewhere. That, I mean, just saying you're in an accident and you can see damage, because all he did was look at photos, didn't do a single test, didn't do a study, didn't do any measurements. He testified at one point, well, the vehicle, the truck was 50,000 pounds. Turns out during cross-examination, he goes, well, it may have been 10,000 pounds. I don't know if that, he wasn't sure of the weight of the vehicles. He said during his testimony, you can't calculate things in a low-speed accident, when that's exactly what our expert did. He essentially says, in a low-speed accident, I get to go up and say, I see damage to a vehicle. I've read studies that say, as long as the vehicle's damaged, a person can be harmed. That didn't qualify.
You're at 2 minutes. Did you want to save that for rebuttal, or you want to keep?
I will, Your Honor. Thank you, Your Honor.
All right. I'll save you 2 minutes. Ms. Peek-Luca?
May it please the court, Megan Peek-Luca for the Appellate. Is there a place where you would like for me to start?
A place? Right where you're sitting is fine.
Is there an argument with which you would like for me to start?
I would think you probably want to rebut his argument. He took his arguments in reverse order. You can take them in any order you want.
All right, I'll start by fact checking what he told you about the closing argument. I would point you to R1339, page 10, at line 13. What counsel represented about what the plaintiff's counsel moved to exclude was not accurate. Plaintiff's counsel told the court that specifically, the court said it was not appropriate to be talking about whether or not a doctor knew that an attorney was already hired when the plaintiff goes to see the doctor. Certainly, to the extent Mr. Dauberly, defense counsel, wants to bring up bias, I don't have a problem with the fact that they knew he was in a car accident. I don't have a problem with the fact that there's a problem to pay the outstanding medical bills from any proceeds of the case. That's fair game. But questions regarding whether Mr. Moore knew he was represented, or whether Dr. Mazur knew Mr. Moore was represented or not, I think based off the case law is absolutely inadmissible.
Well,
And
I
the
think his
reason
argument is, I think his argument was they took advantage of that ruling to misrepresent the timing of the representation. Is that true or false?
That is absolutely false, Your Honor.
Keep going.
Mr. Moore's counsel explained during this hearing, look, my problem with that line of questioning is because it suggests that we, as Mr. Moore's lawyers, sent him to go see Dr. Mazur. We did not do that. Therefore, we don't want this question to be asked. And the judge said, I agree with you. The case law supports you. You got to redact that portion of the question. So we get to closing argument, and defense counsel, in a very smooth way, suggests to the jury, because they had agreed that they were going to redact dates, somehow this date on the LOP, and I encourage you to go take a look at the LOP. It is at R817. The date slips through. Defense counsel puts it on the overhead and he says, hey, jury, go take a look at this. It's dated 11/21/17. That's 11 days, 12 days after the accident. And here it says, I authorize and direct my attorney to make payment. And he's making the suggestion of exactly what we tried to exclude, which is that Mr. Moore's lawyers sent him to go see this doctor, so the jury shouldn't trust what the doctor has to say. So Mr. Moore's counsel got up on rebuttal, and what he said was, we became involved in this, and he's pointing to the LOP, January 3rd of 2018. And he says the purpose of this letter to Mr. Griffith, and what he's referring to, is R818, which is a fax from orthopedic specialists to Mr. Moore's lawyers saying the purpose of this letter is to advise you that we have a signed promise to pay on file in our office, which we are forwarding to you with this letter. So Mr. Moore's lawyers are saying, look, we didn't become aware that there was an LOP until January 3rd. All he's doing is saying, to the extent that the defense is suggesting that we sent him to the doctor, we didn't do that. Defense counsel understood that that is what happened, because when defense counsel moved for his mistrial, he said, for the record purposes, for the statements that were made in rebuttal closing regarding the timing in which the plaintiff's firm became aware of the letter of protection or promise to pay, and that's at transcript 928, lines 20 through 25. And the trial judge, who was sitting there and watched what happened, watched what was pointed to, said, I find that absolutely nothing occurred in the presence of the jury that would reach the level of diminishing the fairness of these proceedings. That's at transcript 919, lines 21 to 24. You all don't disturb decisions like that lightly, because you have said that the trial judge has a superior vantage point that we don't get from a cold reading. The trial judge saw it, even defense counsel saw it. The way that it is being characterized in the briefs and at oral argument is contrary to the record. And there is no, I think counsel, the other point that I wanted to make was that the defendant has never articulated any kind of prejudice that resulted from this. It is a tangential argument about the credibility of a doctor's testimony. There was plenty of other testimony in this case that supported the only issues, which were causation and damages. The error is harmless. Defendant has never tried to articulate to you how the prejudice could occur. And the only thing that defendant can rely upon is this line of cases that says that it's error to allow a party to exclude evidence and then to point to the absence of the evidence. That is not what happened here. As to the Daubert motion and the striking, I spent a lot of time in the brief laying out the procedural history. The defendant never complied with the pretrial order. The plaintiff always complied with the pretrial order. Mr. Kowalski was disclosed timely as a rebuttal expert consistent with the pretrial order. The defense moved to strike him, and the court basically said, look, and I'm reading from the transcript, and this is in our appendix at page 50. What's good for the goose is good for the gander. You, defense, want me to strike the witness from potentially testifying in rebuttal because they didn't have enough to really prepare you for a causation expert who was disclosed as late as he was in the game. Essentially, hey, defense, listen, you all messed around and you disclosed Dr. Kowalski way late in the game. On March 29th, about 10 hours before Dr. Kowalski's deposition, the defense gave 756 new pages, 372 new images, and 108 new videos that were going to be relied on by Dr. Kowalski. The judge had previously said at the first motion to strike, I'm going to call him Dr. K because the skis get hard for me. So the judge said, look, plaintiff, give them Dr. K's opinions by tomorrow. All right. Well, during that hearing is when the defense document dumped all this information about Dr. Kowalski's opinion. And the plaintiff said, in response to the defense's renewed motion to strike, look, Dr. Kowalski is a rebuttal expert. We can't tell you what he's rebutting until we know what the information is, which is why we couldn't give you his opinions the very next day, because you waited until the absolute last second to dump all this stuff on us. And oh, by the way, the reason that Dr. K did not appear at his deposition is because of a death. The court goes off the record, but we do know that it involved the death of his ex-wife. It was personal, and the judge apparently had no problem saying, okay, that's a justifiable excuse. And that's all that's required, Your Honor, is that it be justified. And so at the end of the day, when the second motion came around, the judge said, look, my effort is to bring cases to trial and to have the jury decide the case based on all the relevant and admissible evidence and the law that applies to the case. He said, we're not striking witnesses unless they're total hacks. So is there a way this deposition can get taken? The plaintiff says yes. The defense takes the deposition 5 days before trial. The defense had a copy of Dr. K's deposition, which they gave to their expert. Their expert testified at trial. He had the opportunity to rebut anything he wanted to about Dr. K's deposition. The defense was able to vigorously cross-examine Dr. Kowalski. They were able to put on opposing evidence. The defense doesn't dispute any of those points. Moreover, let's say that the judge did abuse his discretion, which I really don't think that there's any way that you can say that two people could disagree about the outcome here. The judge clearly applied his discretion. It was a mess how late things were happening. And I don't think his decision was an abuse to just say, you two made your beds, go lie in it. You're both going to get late depositions. You're both going to get to trial. Make it happen. And they did. But even if that was an abuse of discretion, it still has to be harmful. And the law is that improper testimony may be considered harmless error where there is other sufficient evidence to justify the jury in reaching the conclusion supported by the opinion of the expert. And here, the only issues at trial were causation of the injuries and damages. And Mr. Moore testified that the crash caused his injury. The jury saw the pictures of the 18-wheeler and the car that was plowed into. Mr. Moore's doctors testified about how it was an acute injury, meaning it happened at the time that the films were taken, which was right after the crash. And Dr. Mahan, Mr. Moore's expert, testified that the findings from Mr. Moore's MRIs indicate that his L4-5 herniating disc was caused by this patient's motor vehicle collision of 11/8/2017. So basically, to prove causation, we didn't need Dr. Kowalski. He was a rebuttal expert. His only job was to say the defense expert's opinions are flawed, and here's why. And finally, on the Binger analysis, the word Binger appears nowhere in relationship to any of the defense's motions about Dr. Kowalski. And there is no case that says that when a motion to strike is denied, that you have to perform a Binger analysis. You have to perform Binger if you're going to strike. If you're going to deny it, even the case that the defense cites in their reply, Allstate versus Lewis, 14 Southern 3rd 1230, a Florida First DCA case, says here a review of the record indicates the trial court did not consider the Binger factors, which it should have. Nevertheless, the record indicates that Appellate was not prejudiced, Allstate did not comply with the trial order, and Dr. Von Thron's testimony did not disrupt or delay the proceedings. Here, Binger says prejudice is the #1 factor. There was no prejudice here. The defense got to take Kowalski's deposition. They got to vigorously cross-examine. I went through that. The objecting party's independent knowledge of the existence of the witness, that goes in our favor because we timely disclosed him. The calling party's potential intentional bad faith or non-compliance with the pretrial order. Again, we complied. And finally, the possible disruption of the orderly and efficient trial of the case. There was no disruption. Both experts testified. So finally, on the Daubert motion, the defense filed a total of 2 pages about Daubert. Their first argument was that Dr. Kowalski was unqualified. Their second argument, which is where the defense focuses, is that the Delta V opinion was not based on sufficient facts or data. They said nothing about that in the hearing. And I would direct you to transcript pages 569 to 573. That's where the defense presented their Daubert argument. No one cut him off. He was allowed to say whatever he wanted to say. I think you can surmise that he chose to abandon the issue because it was all based on the idea that Dr. Kowalski did not inspect the vehicle. Well, neither did Dr. Kowalski, the defense expert. So it was going to be tough to say Dr. Kowalski's methodology is accurate, even though he didn't inspect the vehicle, but Dr. Kowalski's is not sufficient because he didn't inspect the vehicle. Regardless of why they abandoned it.
That would have gone to weight, not admissibility, correct? Regardless. That would have gone to weight, not admissibility. Okay.
Absolutely, Judge Lanty. And regardless, the defendant never argued to the trial court that it needed to, well, defendant is arguing here that the trial court should be reversed because it didn't perform a Daubert analysis. To the contrary, the parties argued about qualifications. That decision is reviewed for an abuse of discretion. Dr. Kowalski was eminently qualified. He had a special grant given him to study precisely the issue that was in this case. And I didn't see anywhere in the briefing where the defense disputed his qualifications. So I think that's a gone issue. Again, I think the defense is hanging their hat on a technicality, and they're saying that it is automatic reversible error because the court didn't engage in a Daubert analysis on an argument that they didn't raise. They wrote it down and they chose to abandon it during the hearing. And the defense has it backwards. As Judge Panavato explained in one of his appellate decisions, it is the decision of the lower tribunal that was reviewed on appeal, not the issue. And that's from Hamilton v. R.L. Best Intern, which is at 996 Southern 2nd, 233 at page 235. Judge Padovano wrote, thus, the preservation of error requirement is not ordinarily completed until the aggrieved party has obtained a ruling on the motion or objection made in the lower tribunal. This court said in Newton versus South Florida Baptist Hospital at 614 Southern 2nd, 1195, pinpoint 1196, a party's failure to secure a ruling on an objection waives it. If they wanted to argue about the facts and data being insufficient to support Dr. Kowalski's opinion under Daubert, they had an obligation to say, wait, Your Honor, you only ruled on qualifications. You didn't rule on our insufficient facts and data. Let's talk about it. They did not do that. Therefore, you don't have a decision to review on appeal. And the qualifications, we listed them at page 26 to 27 of the answer brief. I don't think that I need to go through them. It sounds like you're fairly familiar with them. And finally, let's pretend that somehow it was improper not to do a Daubert analysis on an argument that was never raised. I think that's absurd, but I'm going to go down my row of ducks. Even if it was improper, again, it's harmless because improper expert testimony may be considered harmless if there is other evidence that supports the jury's conclusion. And here, as I explained before, there is other evidence. Nothing Dr. Kowalski said was necessary to prove that the crash in this case caused Mr. Moore's injuries. And with that, I think I covered the watershed.
You have? All right. Thank you. Mr. Butler, you had 2 minutes left.
Thank you, Your Honor. So first off, with regard to the improper closing argument, what I didn't hear is any justification for how plaintiff's counsel blatantly misrepresented the timing. There's no argument that that was wrong, because what we have is the doctors saying in November this law firm was involved. Plaintiff's counsel said they weren't involved until 2 months later. That was false. I think the authorization itself, the form, is somewhat of a red herring. It's one issue, but I find it interesting that they're arguing, well, the LOP, it was a mistake the date wasn't taken off. That shows that everyone did understand that the judge's ruling was to take the dates off things, because there's also no express ruling to take the date off the LOP. Yet Appellee's counsel has said in their briefs and said today, well, that should have come out too. But they also want to say, but the court never actually excluded the authorization. Which is it? So clearly everyone understood that that's what the court did. But even if you take the authorization out of it, you have two doctors that the court expressly said, take the dates out, that testified that the plaintiff's law firm was involved in November, and plaintiff's counsel says the exact opposite during closing. We shouldn't condone that type of conduct. With regard to Dr. Kowalski, what I saw is that at page 1350 of the record, a hearing before his deposition, defense counsel is arguing this doctor has been struck based on Daubert before as a biomechanical expert. We're going to need a Daubert hearing. Then the very portion of the record that was cited, they said there was a Daubert hearing. It's really just a few moments before he's brought up. The court says, and I tell you to look at the record at page 568 of the trial transcript. The court says you want him not to be able to testify at all due to some Daubert concern that his analysis wasn't based on sufficient data. And he goes on to say, is that a pretty fair summary of your motion? And defense counsel, Mr. Dubberly, says, yes, sir. Court says, all right, give me any additional argument.
Mr. Butler, before you continue, you are out of time. You want to wrap up in one sentence, 5 seconds?
Yes, Your Honor. The idea that the Daubert challenge was somehow abandoned when the trial court properly noted that the challenge was to the methodology. And if you examine the
okay, I'll let you go over. You're well over the 5 seconds.
I would ask
Out of
that
time.
the court find the trial court abused its discretion on one or both issues raised on the appeal and reverse the trial court's denial of the order denying motion for new trial. Thank you, Your Honor.
Well argued. Thank you both. I think that concludes the calendar. We'll be in
You guys are
recess.
finally done.
Have a nice day. We're finally done. You're right about that.
Thank you.
Bye-bye.
Bye.
Bye-bye, hon.